court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case on the docket scheduled for oral argument this morning, the case of West Boca Medical Center Incorporated versus Florida Department of Revenue. Counsel ready to proceed?
Yes, Your Honor.
You may approach, counsel.
Thank you.
We will allocate 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. 3 minutes, if I may.
So noted, Madam Clerk. You may continue, counsel.
Thank you. Good morning, Your Honors. May it please the court. My name is Will Hall. I have the honor of representing the appellant, West Boca Medical Center, in this matter. For three main reasons, this court should reverse the trial court's order granting summary judgment to the department. First, the trial court erred in concluding that West Boca's arguments in summary judgment were not pled or preserved in its amended complaint. Second, the undisputed material facts in the record, as well as what we contend is the proper application of the law to those facts, reflects that West Boca was entitled to summary judgment and not the department. And third, alternatively, if this court disagrees that West Boca was entitled to summary judgment, then material disputes of fact would prevent the entry of summary judgment for the department, in which case this case should be remanded for a trial on the merits. Going first to the amended complaint, I'd submit to you it's hard to see how the amended complaint and the summary judgment motion from West Boca could be any more aligned. In both of them, West Boca made very clear that the services Crothall Healthcare provides to it, which are hospital and healthcare specific, are not the type of services discussed within or categorized within NACIS code number 561720. That was the very basis of the case from the start. Throughout discovery, evidence was elicited, including evidence as to what Crothall itself reported was its NACIS code for that pertinent tax year, not the one listed in the statute. And all of that was the basis for summary judgment, that these services are not the type that's taxable pursuant to this statute, especially in light of the strict construction that this court has to give of this taxing statute against the department. They really fit hand in glove together, and I'm not frankly clear as to why the trial court found otherwise. So we would submit that clearly those arguments were preserved to the extent there's an argument from the department that somehow we had to amend our complaint anytime we received evidence supporting that argument. I'm simply aware of no rule, no case law, anything to that effect. So we'd submit all of this was properly preserved. Going to the summary judgment motion itself, we really have to start with the construction of the pertinent statute. Is it ambiguous or is it clear on its face?
Because counsel, yes. What language in the statute do you believe equates the taxability of a service with the NACIS code reported on a federal income tax return?
The parenthetical reference, Your Honor. Especially, so the first thing this court has to decide is what is the meaning of that parenthetical? And as I believe the department itself has conceded in the briefing of this case, there's two possibilities for how you can interpret that. One is that it's merely illustrative, that it's simply an example of what's taxable or something to that effect. The other is that the parenthetical is definitional, that what the legislature has sought to tax is what's categorized in that NACIS code. Otherwise, as we submit, I'm not sure what the purpose of that parenthetical is.
Do you believe that a NACIS code reported with an agency per se establishes its services are taxable under the statute to the exclusion of any evidence of the nature of the actual service provided?
So two points to that, Your Honor. I would say as a general matter, no, but the one thing I think this court, again, has to remember is how this taxing statute has to be construed. We always talk about separation of powers kind of in a separation between government entities, but one of the most essential separations this court has always recognized is that between the government and the people, that the government can tax, but it cannot tax by implication. The government can only tax what it has clearly and unambiguously stated that it wishes to. And so what the exact effect of that NACIS code is, whether it's dependent on what the company references, whether it's dependent on all the facts, is in and of itself ambiguous and triggers the strict construction. But in this particular case, the facts support the NACIS code that Crothall Healthcare's parent corporation has given us. The facts support that this is not just the type of maid or janitor service that's gonna come and vacuum the floors here at some point tonight. It's done for a different purpose in a different way. I think everyone would agree, and the record reflects through the testimony of Karen Chow and others, that simply doing traditional maid and janitor service is not sufficient for a hospital, for an OR, for a NICU, for places where hospital-acquired infections are a possibility, as has to be protected against for federal regulations and otherwise.
And that sort of bleeds into another issue that I found relevant here, and certainly we read a statute as a whole.
Yes.
So we look at subpart 4, which allows parsing. So obviously there's a recognition by the legislature that all categories, all jobs may not fall neatly within these codes. So you can parse out certain services, some exempt, some non-exempt. So here, did you plead or parcel out, or is it your position, it's as a whole, it's all or nothing?
So I believe that's certainly the department's position, that they're saying that everything Crothall does is in and of itself just maid and janitor services. We've said from the beginning that we believe what Crothall does is materially different. And we believe that that's fully preserved in the amended complaint, and argued that Crothall is not a traditional janitor service. And in fact, the record reflects, does not want to hire those who have been janitors and maids in the past because they would come with bad habits and not understand what this job entails. But if there's any dispute of fact as to that point, as to whether maybe Crothall does some things in the administrative offices or in the cafeteria that are different in kind from the OR or the NICU or the places where, for example, the record reflects Crothall has to, at times, its employees wear full-length PPE or N95 masks to go and clean.
Do you
That's
think
it.
that has to be specifically pled as an alternative?
Your Honor, I don't know, because again, we're talking about a strict construction of the statute against the department, right? When we're talking about exactly what this statute means, what we're saying is that 561720 seeks to tax maid and janitor services. We think that, especially if you find ambiguity in the statute, which we believe there is, I don't think you can read that statute in and of itself and just say it's clear on the face what this means or what this parenthetical reference does.
But
You have-
counsel, is there a separate nexus code for businesses engaged in hospital-based cleaning or disinfecting services?
I'm not aware of that specific code, but there is a code, which is the one that Crothall's parent corporation has reported, that goes to those that provide a combination of services, such as what the record reflects Crothall does. Crothall not only cleans the offices and all that, it also, as the record reflects, has roles in needle disposal, biohazardous waste disposal, things that no traditional janitor or maid service would engage in on any regular form. Also linen disposal, things of that sort. So the record reflects that the NACIS code Crothall has reported is frankly proper. It fits the evidence in this case, that they're not just performing maid services.
The statute does include an exemption or an exclusion. For instance, excluding cleaning of interiors of transportation equipment, is that correct?
Yes.
Seems like if the legislature wanted to exclude businesses engaged in hospital-based cleaning or disinfecting services, they could have done so, couldn't they?
It could have. It also could have not included the NACIS code reference. And we have to be very careful here as we read the statute, obviously not to step into the shoes of the legislature and try to fix what is an ambiguous statute for them or rewrite it to do what we think the legislature might have intended or might have sought to do. If the legislature wanted to tax all non-residential interiors except for transportation equipment, there's no purpose to the NACIS code reference. It could have just put a period at the end and it's done. But it did include that NACIS code reference. And why did it do so? You can't decide that without going to canons of construction and then triggering the strict construction against the department. Once you go to, as I understand it, the department's reading of that statute is, there's a plain meaning because you get to the parenthetical reference, which I believe they contend is just purely superfluous, but I'll let them speak to themselves. But you get to that code, which requires you to consult a manual, which talks about what business folks are primarily engaged in, so you have to decide what that means. Then you look at illustrative examples in that manual, one of which is service station cleaning and degreasing. So what the department is telling you is you can clearly and unambiguously see that the cleaning of a OR or a NICU is taxed because of a manual that gives an illustrative example of service station cleaning, that's couldn't possibly be farther from an unambiguous statute. I just don't see that at all. We do contend as part of this argument, of our summary judgment argument, that there is a stipulation of the parties as to Crowthall's NACIS code. We think that's clear from the record, but if the court disagrees, we still are entitled to summary judgment because of the evidence in the record of what Crowthall does and why Crowthall does it. We submit it's materially different from a maid or janitor service. And if you apply anything akin to the associated words canon or any other canon of construction, I just don't see how the illustrative list in the NACIS code manual leads you to anything resembling a clear and unambiguous statute. Couldn't be farther from that. But just a few things that differentiate Crowthall and take it outside of anything that could be considered just basic non-residential cleaning as categorized. Again, why does it do what it does? This isn't just about a tidy appearing hospital. West Boca has to meet CMS standards, Joint Commission standards, as to infection prevention, not just tidiness, infection prevention. There's testimony from Karen Chow on the record as to why they do what they do, how they test, not just for dust, but for the spread of infections that could affect all the people in that hospital.
Is it Courtroom's cleaning service or West Boca's medical center itself that is subject to regulatory oversight?
It's West Boca. That's the service. Crowthall's service is what is the leading kind of the tip of the spear for West Boca meeting its CMS requirements for preventing infection spread, for infection prevention. So it's not, again, this isn't about getting 5 stars on Yelp. This isn't about an office or a restaurant trying to appear tidy. This is done for a materially different purpose from what anyone could categorize as traditional maid or janitorial services. So Crowthall provides those services to West Boca, so West Boca can meet its CMS requirements.
Just because there is a regulatory scheme addressing the cleaning of the facility, does that necessarily mean that it's not janitorial services?
It's more about the why. Why is there that regulatory scheme? It's because, again, it's because it's not just about cleaning the way someone's going to clean this courtroom. Someone's going to clean this courtroom tonight. Someone's going to clean West Boca tonight. I think everyone would agree that after this courtroom's cleaned, it's not going to be ready for surgery. It's not going to be ready for a NICU, right? It's done for a materially different purpose, and that's to prevent the spread of hospital-acquired infections. So that's
I guess what my question though is, does that mean it's not a janitorial service though? Like just because you're cleaning it there are different kinds of areas need different kinds of cleaning. Restaurants need different cleaning than courtrooms. But does that necessarily mean it's not janitorial service?
Your Honor, what I'd say is even if you could get to that place that you think it's akin, you can't get there with the required strict construction against the department. If the legislature wants to tax every bit of non-residential cleaning, houses, courtrooms, hospitals, nuclear waste facilities, they can do it. For any purpose, they don't need a NACIS code reference. All non-residential cleaning, period. If they want to exempt transportation equipment, add that in, period. They haven't done so. What we have is an ambiguous statute that you have to construe against the taxing authority. Doing that, I believe the strict construction you have to give is that the examples in the NACIS code manual, the examples in the department's rule, are those of a traditional maid or janitor that's not doing the things for the purpose that West Boca does. It's not similar in kind. That's the entire purpose, as I understand it, of the associated words canon. Are clumped examples, clumped terms in a statute or a contract similar in kind? They're not in this case. But even if the court disagrees, with our reading of the statute, then we have to go remand this case back for a trial. We have provided counter evidence to what the department has offered to show that this is not traditional janitorial cleaning. Even if your honors have questions about exactly why it's cleaned or for what reason or how it's done and all of that, that has to be decided at a trial. We can't just ignore the fact that Crowthall doesn't want to hire prior maids and janitors. Crowthall wears at times full-length PPE. When they go in and clean a room after a person with an infection's been there, do a terminal clean, yes?
Yeah, so let me ask you a slightly different question about the ambiguity issue. Is it true that every time we look to a canon or use a an interpretive tool that has a place in the canons, that necessarily means the statute is ambiguous?
Not necessarily, right? Not necessarily. I think that what's been talked about, in, for example, the Dream Defenders case is you have to look at everything in context. I don't think it necessarily does, but what you have here is something that's frankly similar to what the U.S. Supreme Court dealt with in the Chickasaw Nation case that we've briefed. You had a parenthetical reference that it wasn't clear on the face what it meant. Now that case was a tax exemption. So you had a strict exemption, a strict construction against the taxpayer. In that case, they said, well, we have the canon that says give meaning and effect to every term in a statute, but we have to counteract that with the canons that say, well, if a term is repugnant to the statute, we don't have to do that, right? So the idea that you use the canon that, for example, you always give purpose or effect, or use associated words canon, whatever it is, hypothetically, could you still find an unambiguous statute? I suppose, but you certainly can't do that in this case, where you have to then take the statute, go to the associated or incorporated manual and look at the illustrative examples and decide whether this falls within the bucket of illustrative examples. There's probably about 3 or 4 canons you have to use to do that. That's not a straight line you have to connect. So even if hypothetically there are cases where you could do 1 or 2 canons, get to a plain meaning, this is not that. But again, even if your honors disagree with our reading, we would submit a trial on the merits. If this does not come down wholly to the NACIS code, if this does not wholly come down to this statutory interpretation we've advanced, then we need a trial on the merits to determine whether Crothall's healthcare services are truly akin to janitors, maids, and all that, or whether they provided a service that's different in kind. Yes, sir.
Counsel, do you believe that a NACIS code reported with any agency per se establishes whether its services are taxable under the statute to the exclusion of evidence of the nature of the actual service provided in Florida?
Your Honor, if Crothall said it was an ice cream truck, no, you wouldn't have to defer to that. But in this case, you have Crothall's parent corporation saying it is exactly what the record reflects it is, a corporation that provides a combination of services to the offices of West Boca, the ORs, the NICUs, linen disposal, waste disposal, needle disposal. That's not akin to maids and janitors as described in the listed code. And with that, I'd ask to reserve. Yes, sir.
One other question.
Yes, sir.
If a business NACIS code as reported on its federal income tax return differs from its NACIS code with the department, which one would prevail for purposes of taxation under the statute?
May I ask, under a statute that's strictly construed against the department? That's one of the first questions. But let's
Under
talk,
the statute in question here.
which we believe should be strictly construed against the department. And in this case, I would say in this case, even more so, the only competent evidence of Crothall's NACIS code for the pertinent tax years is the affidavit. Because let's talk about what the department has provided. The department has said that to counteract what Crothall says its NACIS code is for the tax years, they're pointing to, from 1999, inputted by, they don't know who inputted it, might have been someone from the department, might have been Crothall, they don't know based on what. There are 4 listed codes, one of which is the one they like. And they're telling you to use that from 1999. We don't know if it's from a person with knowledge against person with knowledge present pertinent to the tax years. I don't even think this one is material counter evidence against what Crothall's reported. So,
Thank you, Counsel. You may approach counsel.
Good morning, Your Honors. Randy Dincher for the Department of Revenue. Before I address the statute, I want to summarize the trial court's findings of material fact. In the final judgment, paragraphs 6 and 15, the trial court found that Crothall's Florida NAICS number is 561720. In footnote 3 of the final judgment, the trial court expressly rejected West Boca Medical's infection control argument. And the final judgment, paragraph 15, the trial court found that Crothall's service at West Boca Medical is the cleaning of building interiors, which is the service that is subject to tax under the statute. West Boca Medical did not present any evidence that contradicts these findings. West Boca Medical acknowledges that Crothall's services are cleaning services of the interior of a hospital, a non-residential facility. We're all familiar, I mean, every day I read case law about interpreting statutes, and supremacy of the text principles apply, which means the court is to give all parts of the statute meaning and avoid readings that would render some parts meaningless. In the first paragraph of section 212.05, the legislature clearly states its intent is to levy sales and use tax on every person who provides services taxable under chapter 212. Here, the department is not setting policy. The department is attempting and has interpreted the statute, the plain reading of the statute. 212.05, 1I, 1B, which I will refer to later as Part B, because it's too many digits of the statute. The legislature declares tax is levied on all non-residential cleaning services. Mr. Hall acknowledges that Crawford performs cleaning services, but ignores the word all. His discussion never once brought up, his presentations in the court never once brought up the operative term all.
Well, and I'm going to ask you the same question about sub 4. Doesn't that provision recognize that all of these companies may not squarely fit within a NACIS, specific NACIS code, so that there is the ability to parcel out?
It does. The problem for West Boca, Your Honor, is it wasn't pled. Not only was it not pled, it wasn't brought up at all. It wasn't pled in the complaint. It wasn't even mentioned to Judge Dempsey. It was brought up for the first time in litigation in their response brief, I think.
So your argument is that sub 4 would be an affirmative pleading?
Yes. Because how do we know? I mean, the purpose of the pleadings is to frame the facts that we investigate in discovery so that we can prepare for trial, to determine what areas are disputed and what areas are not. So if that's not in the pleadings, how, we're doing, going down a deep hole and deep dark hole in discovery, trying to guess what's going to happen at trial. They never preserved it. And they never attempted. They had plenty of time. The discovery took quite a while. We inspected West Boca. There's pictures in the record of the facility. There's pictures of the janitor using a mop and a bucket. And, we did quite a bit of factual investigation to make sure that we were right, that the department was correct in its interpretation. And they use a bucket and mop and a janitor's car.
Whether or not there's pictures of a janitor in a hospital, does that really tell us what the meaning of the code is in the statute? I mean, isn't this about why that code exists in the provision? What does it mean?
Well, you have to look at the four corners of the statute to determine. Unfortunately, we're only dealing with one statute here, so it is a little easier than some of the other stuff we contend with in other cases. But you have to look at parts B and part 2 together. And first off, I would suggest you start with part 2, which defines NAICS to mean those classifications contained in the North American Industry Classification System. The legislature specifically, in part 2, specifically tells you why they're using the NAICS system to classify. Then in part B, the legislature, in part B, the legislature tells you that all non-residential cleaning services are included. The parenthetical reference is purely punctuations. Punctuations are like periods, commas, and we have parentheses. Periods and sentences. That's pretty clear. When you read a statute and there's a period, you know that sentence is ended. Commas, you've got to
you quoted the statute. How does the department interpret the statute?
Narrowly as written. All non-residential cleaning. They interpret what's contained in the parentheses as limiting what's subject to tax.
Is a parenthetical reference to NAICS code definitional or illustrative?
The term definition takes me down a rabbit hole. to interpret this statute, I suggest you look at what the trial court did in paragraph 12 of the final judgment. She looked at the statute, and along with the statute, she looked at the NAICS code. And if you replace the terms of 561720 in the statute, you know exactly what the legislature meant. The legislature could have used more words in the statute, but the use of NAICS code has been effectively used by the legislature, not just in this statute, but as in the Tribune case, they used an SIC code, which is actually still a statute that's in the books. They use it. They just incorporate codes, federal government codes for classifications.
Which is to say that it's descriptive of non-residential cleaning. For B, it's non-residential cleaning, and these are the kind of things that we mean by non-residential cleaning and pest control services. Am I understanding you right?
56172 limits the cleaning to building interiors. If you didn't have 56172, if the legislature didn't put in 561720, then the department would be collecting tax on services that it did not intend to tax, which would be like the outside of buildings, power washing buildings.
So they're definitional.
Non-residential. It limits.
I mean,
the
that
tax.
argument really supports a definitional label.
If you use, I get uncomfortable with the term definitional because I have I used it in the brief because I was interpreting other case law. They do use it as definitional. Basically, the department employees read the statute, plainly interpreted it. They're non-lawyers. The auditors. Now, this was a refund, so the burden is on West Boca Medical to prove that they're entitled to the refund. But they reviewed the entire statute. They also looked at their rule, which explains West Boca Medical has not ever mentioned that the rule is ambiguous, there's no authority, that it goes beyond the statute. The rule helps to explain the statute. So when you read the two together, the parentheses to me incorporates that specific NAICS code, which limits the tax. But I suggest the court review the final judgment, specifically paragraph 12. The judge explained that section 212.05 1I2 explains the use of NAICS to mean those, quote, those classifications contained in the North American Industry Classification System as published in 2007. NAICS 561720 janitorial services states, this industry comprises establishments primarily engaged in cleaning building interiors, interiors of transportation equipment, and or windows. And the judge went on to say, giving full effect to all the words of the subject statute, together with the NAICS code, brings a plain reading of the legislature's intent.
Council, does every business in Florida has a NAICS code with the department?
Your Honor, I can tell you what they do now. I'm pausing, okay, because I can't answer that. What I know now, currently, and this Crothall registered in 1999. Mr. Hall correctly represents that. Then it was a paper form. The businesses filled out the form, and then it went to the Department of Revenue. There's also like an interface with another agency that some of the information merges into the department's database. Now, when a business uses, and it's a DR1 form, which I find to be an interesting number, it's like the start, right? The start for a business doing business in Florida. Now it's a drop-down menu, and there are NAICS code options, and the taxpayer, that is the business that is registering, can choose any NAICS code number it wants. Back then, we were not able, the Department of Revenue, that form that Crothall filled out in 1999, they actually looked for it in their archives. It's been destroyed. It exceeded 20 years, and they don't have it anymore. So I can't report on what Crothall's form was back in 1999.
If the businesses reported NAICS code subject to verification and correction in Florida?
I can't answer that question either for the Department of Revenue. I also think there's an interface with a different agency. at least one agency that may put information in the database. What is known is the information in the database predates this litigation. Crothall registered in 1999 doing various business in Florida. One of the business codes is the same code that's in the statute. We know that from the evidence in the transcript, Crothall's corporate representative testified. He said, yeah, we've been at West Boca years before this version of the contract with tenant. And the contract with tenant, and again, the contracts with tenant are housekeeping. And there's multiple versions of the contract that for this audit period. The contract that Crothall has with West Boca, the local facility, is also housekeeping. What we know is West Boca has been providing the same housekeeping services at Crothall since before this litigation. They've been providing janitorial services in the state of Florida since 1999, and today they continue to provide janitorial services and housekeeping services in the state of Florida. So there would be no point for Crothall to update. Moreover, West Boca has no standing to demand that Crothall update its records and in the database.
Well, I mean,
Go ahead.
Crothall puts in the sales tax and it's charged to West Boca, so
Correct.
really Crothall doesn't have the priority to make a change because they don't suffer the taxation, right?
Well, but they're subject to audit, so if they did not collect it and they were audited, they would have to pay it, and they could not then later bill West Boca for it. So they're responsible for collecting and remitting the tax. West Boca, as a customer of Crothall, is responsible for paying it.
Well, they're subject to audit, but it's not out of pocket for them.
It would be out of pocket
Unless
for
there's a
Crothall
violation of
if
audit.
they didn't, and that often happens with taxpayers that fail to collect a tax that they should be collecting and they're not.
Right. Why is the NACIS number the so secretive, such a confidential? Because I mean, even in this case, there were documents that were under seal with respect to the numbers that had been provided. Why is that so confidential? Why is it not public record?
We have 212053 subsection 2, I believe, that requires the department to keep confidential other taxpayer information. So if the Department of Revenue employees or myself were to release other taxpayer information, and Crothall, as it pertains to this case, is another taxpayer. If we did not keep that information confidential, then we would be subject to criminal sanctions and termination from our positions.
Just that
It's in
NACIS
this-
number in and of itself.
It's because it's Crothall's taxpayer information, so we could not release it. And in fact, in releasing the affidavit, I reached out to Crothall's attorney and got permission before we presented it to the judge, even though we were presenting it under seal, because they have an opportunity to challenge it. It doesn't seem sensitive to you and I, but the sanctions are very large, and we uniformly do our best to not bring in any other taxpayer information. It often comes up, it could come up in a deposition, somebody says, well, what about this case and that taxpayer? We're like, whoa, no, we're not answering that. You got to get a court order. Figure out how you want to get that in. We're not answering that. Even a harmless type of request, like here you would think, I don't think, like when I look on the Sunbiz, which is the website, you don't see NAICS numbers on there. You see, interesting enough, you see federal EIN numbers, which I would think would be confidential, but whatever. But you don't see the state. The state has BP numbers for businesses. Those are not. Those are not on the website. When I introduce evidence in cases like this, I do my best to redact both the FEIN number and the BP numbers, which is Florida's alternative to like a Social Security number. All right, I don't know. I don't have much time left. I want to mention a couple of things. Oh, I asked the court to look at the Tribune case, and I've looked at it carefully recently. What I find Tribune was, now first the Tribune in this case were refund applications. The burden of proof in refund application is on the taxpayer seeking the refund. Tribune's SIC number was different than the statute. 212087YY is still an active statute, and that was the statute that was in Tribune. I request that you consider looking at that, and then this case. That statute, 212087YY, does not use parentheses, and the phrasing of that statute is different. And even then, this court, the First District, said in 2010 that the trial court, this court reversed and remanded, and in doing such, this court stated the trial court perhaps focused too narrowly on the SIC number, and that's in quotes, that's trial court's words. Tribune statute uses the word business, and then, which would indicate that a business registered under a certain number, but that wasn't how the appellate court looked at it. In Tribune, it says also exempt are the following materials purchased, produced, or created by businesses classified under SIC industry numbers, and then there's a series of numbers. And the court in Tribune had initially denied the refund. But Tribune was also asking for the Department of Revenue to update its SIC number to qualify for the exemption and then grant the refund. Here we don't have that. West Boca is not asking the department to update Crothel's number. The other thing I want to talk about is the disputed issues of material fact. And I want to point out to this court the Whitlow versus Tallahassee Memorial case that's cited in my material on department's answer brief, page 22. I don't discuss it, but when I was considering, like, what is a disputed issue of material fact? In Whitlow, Ms. Whitlow sustained injuries when she slipped on water that was on the floor at Tallahassee Memorial Hospital. On a motion for summary judgment, Tallahassee Memorial Hospital would move for summary judgment, which was granted by the trial court, because Whitlow failed to show evidence that TMH employees had knowledge of water on the floor. This court, and that decision is a 2023 first DCA decision. This court stated, in the end, Whitlow left an evidentiary gap regarding knowledge of the water on the floor. The record at best shows that the nephew was the only one who saw the dripping stretcher, and the mother was the only one who saw water on the floor. There was nothing in the record to establish knowledge on the part of TMH employees that could be imputed to TMH, and there was not enough from which to reasonably infer that knowledge. No reasonable jury could find for Whitlow at trial. Here, there is no dispute that Crothall provides cleaning services at West Boca Medical. There is no dispute that West Boca Medical is a non-residential facility. There is no dispute that Crothall's number in the department's database is NAICS number 561720, the same number that's in the statute. There is no dispute that Florida's database does not have 561210 for Crothall. The evidence for the Florida number is the department's affidavit, employee affidavit, which explains the relevant code reporting in the Florida database, and screenshots of the actual database plus a deposition transcript. As to information from Compass, Compass has on its federal consolidated income tax return for 2018, 19, and 20, it reports for Crothall 561210.
Counsel, before you sit down, I have a question regarding the code as well as the statute. For purpose of taxation under the statute, would a business's NASH code as reported to the department prevail over the nature of the actual service provided in the event of a discrepancy?
Now, to my knowledge, the Department of Revenue is uniformly applying Tribune case. So if it was an error, let's say Crothall repairs bikes and it was in the wrong code was in the department's system, Crothall would not be subject to the tax under this statute. No, it's what services are provided. And the great weight of the evidence here is for the services.
Thank you, Counsel.
Thank you.
couple of brief points in rebuttal. I believe I just heard my esteemed co-counsel say that you're only taxed if you're assigned NACIS code number 56720. Well, first of all, Crawthal's assigned 4 numbers in the department's database. They're just choosing the one they like and just ignoring the other 3. So which of the 4 applies in and of itself would be a dispute of fact. The other thing I would say is, for the department to say it's strictly construing the statute, they've advanced an argument to you that even if Crawthal's NACIS code is 561210, it's still taxable because the first 3 numbers are the same. That's not at all a strict construction. They're reserving for themselves the ability to say that other numbers are subsumed within the listed number. Ms. Dincher referenced the applicable rule interpreting the statute, 12A-1.0091. That rule states that the department is seeking to tax what's enumerated under this specific NACIS number and then gives more illustrative examples. So the question I'd ask the court is, if the statute is so clear, why do we need guidance in the form of a rule? Why do we need more illustrative examples, all akin to maids and janitors, if the statute so clearly and unambiguously taxes every cleaning of every building interior? We don't. Clearly, there's ambiguity here, and the department, I think, even recognizes that. The other point I'd say is, to say there's no dispute of fact would require the court to ignore what Crawthal does and why they do it. The fact that Crawthal does not want to hire prior maids and janitors. The fact that it has to prevent hospital-acquired infections, full-length PPE, terminal cleans, all the things that bear no resemblance to maids and janitors as listed in those illustrative examples. Thank you, Your Honors.
Thank you, counsels, for your respective oral arguments this morning. We are adjourned.
Good job, Randy. Yeah. Good to see you.